For those of you who don't know me, my name is Debra Oppenheimer, and I have been handling covenant enforcement for a very, very long time. I think we're going on 17 years now. So one of the primary things I try to do is give you some options, but obviously what I can't do oftentimes is tell you all the exact ways that you can handle it, because your covenants are always going to take precedence. So I'm going to try and give you some ideas of what to deal with. Today, we're going to talk about how many times board members and or managers are harassed. On your screen, you should see my PowerPoint up in the center of your screen, and that should take up most of your screen. And then obviously my face is as small as possible, and it's down there in the corner, so you don't have to stare at me too much. On the left side of your screen, you should see a box with a question mark in there. If you have a question for me about something we're talking, feel free to type it in there, and I'll try and get to it as it's coming up. If not, at the very end of the program, I will try and get through all the questions. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report, and then we will send you an email within about 48 hours following the webinar. Credits aren't transferable. If you have questions about education program itself, please email education@altitude.law or call Sean directly at 303-991-2076. And if you have problems with your CMCA credit, same information, call Sean or email him. Obviously, when we're done with this, we do keep these recordings, and they're available on ACE YouTube site or the YouTube channel. So again, what we're trying to talk about today is, how often board members or managers are harassed, whether it's, disrupting meetings, nastygrams, or, lies about the board member and the community. So we're going to try and address that topic and what options you can try and deal with it. As always, please feel free and do know we put a lot of resources on our website. We also have a lot of information in our newsletters and our blogs that go out. I believe you all got emailed the slideshow before the class. So let's talk about what is harassment. I can tell you that board members' opinion of it, managers' opinion of it, and even homeowners' opinion of it is going to vary greatly. Obviously, what we're talking about is what's kind of in number 2, which is when it's an unpleasant or a hostile situation, it's uninvited or unwelcome verbal conduct. What we often see and what most homeowners think of is what our covenants look at. And our covenants frequently have some language in it under the nuisance paragraph that talks about annoyed, or if conduct of another owner annoys them, and they think of that as harassment. As managers, you know this already. As board members, you are probably familiar as well, which is, not everything that happens to a homeowner is something that you can fix. There's going to be situations that homeowners are going to be very upset about and they're going to complain about, but it's going to be outside of your control and or your ability, because your control is what your covenants give you. So there's a lot of times that you might hear of harassment, and it's not going to be something that you're going to deal with. You always want to look at what your control is and what your authority is in the covenants, and remember that if it's about safety, you need to be thinking police. That's not your job to worry about somebody's safety. If it's security, you want to think about police. We are supposed to be enforcing the covenants. And so if in fact this harassment affects our community and the covenants, then we want to get involved. If it has to do with safety or criminal harassment, that's a method for the police. This statute, the criminal harassment statute, has been amended numerous times in the last few years. They have tried to bring this into the 20th century and deal with the fact that a lot of harassment comes by computers. And so you'll see in E, they did try and update it, whether or not their email is harassing or whether it's a phone call harassing. But again, you have to remember that not simply everything is going to fall under this statute. And there's going to be a lot of things that come in that aren't going to be criminal harassment. And, you know, certainly that's something that whenever some homeowner complains to you that they're being harassed by somebody, if it's a safety issue and they're concerned with that, direct them to the police and try and get them to understand that's not your job to fix. What about civil harassment? This, you know, again, civil harassment in the courts generally looks at sexual harassment, discriminatory harassment, or workplace harassment, okay? It's a different type of issue than what that first definition was. Webster's, what's it mean when somebody's harassing you? When the courts are looking at it, it's got to be more than just, you know, your brother's, you know, your little brother poking fun at you until you want to punch him back. That's not the harassment that, you know, is going to make it in a courtroom. What we're talking about is the harassment in an HOA setting. And as I said, not everything is going to be within your authority. So we got to start with, how does harassment kind of bump into HOA living, and how is it you become responsible for anything? Well, one of the things that we have seen over the years, obviously when covenants were first implemented years and years ago, how people treated one another wasn't even dealt with. That wasn't the purpose of a community. I mean, the main purpose for covenants years ago was that very first one: maintain, preserve, enhance, and protect the community values, protect how the common scheme of the community, how it looks, how it was designed, what the community was going to look like in years from now. But as covenants have had more multifamily units, more townhomes, more condos, harmonious community living became part of the purpose of the association. And so as managers, you then got dumped on you the obligation to try and make people have manners and make people responsive and remember to be polite to their neighbor. So we had a question of, what did D mean on the prior slide? So as I said, when that slide came up, going back, come on, there we go. This statute has been amended numerous times. There used to be a provision in D, and it got revised and removed. So that's why it just says repealed, because it is no longer there. What used to be there has been changed so many times. So for us, harassment generally comes up in three different ways. You know, again, we see managers harassed, we see board members harassed, and we see neighbor to neighbor harassment. So that's how we kind of come up with it and how we look at it. And we're going to try and go through some of the situations and deal with what you can do and what you should definitely defer. Okay. So obviously managers getting harassed by owners is part of the job. And not everything that happens that is harassing by a homeowner to a manager is something that we can stop. And so we'll have to kind of talk about how that happens and what you can stop and what you're going to have to just tolerate and kind of shrug off. Board members get harassed, obviously, by owners. And since the statute requires that board members' emails are available to owners, they're getting a full dose of a lot of the stuff that managers have gotten for years. We obviously see owners harassing each other. We've seen owners harassing vendors. Certainly when we're talking about that, we're going to have a lot more abilities to deal with it. All right. So let's look at the owners harassing vendors. That's probably easiest of all these to deal with because they have no right to contact the vendors. The only contract is between an association and a vendor. And if anybody interferes with that, it's called tortious interference with contract. So if you have any homeowner who is trying to tell your if you have any homeowner who's trying to tell your vendors how to do their job, you can tell them, hi, that's tortious interference with contract, because they have no right to direct the vendor on how to do their job. One of the questions I got is, isn't the manager technically a vendor? You are, but part of your duty is to be the liaison and the contact between the homeowners and the board. So part of your job duties require that you take communications from homeowners. There's nothing written, let's say your snow vendor, there's nothing in their contract that snow removal vendor has any duty to talk to a homeowner. It's not in their contract to talk to a homeowner. It's in their contract to do what the board has directed them to do for snow removal. Unfortunately for managers, it's in your contract that you're that liaison and you have to talk to those homeowners. So it's not an interference or a tortious interference for a homeowner to call you, because it's part of your contracted duties to take those calls. Managers or board members accusing or harassing owners. Accused of harassing owners. We often have homeowners write in when they get that violation notice, you're harassing me, stop harassing me. Well, obviously it's not harassment if in fact the covenant set forth that you will send them a notice if they're in violation. And so if you go back to like the criminal statute says contact for no legitimate purpose is harassment. Well, you have a legitimate purpose. They're in violation of the covenants that they're mandated to fix. So therefore, when the homeowner says, you're harassing me by sending me a violation notice, you can go, no, I'm not. You moved into the community has requirements that you're supposed to meet. And when you don't meet them, the covenant enforcement policy says, I'm going to send you a letter. So you have a legitimate purpose for sending the letter, and it's not going to be harassment. Well, how do we deal with the situation where the owners are harassing the manager or the board member? That's the one that is, probably that we see a lot, and one that you want to take a look at. So obviously, as I said, part of the duties of a manager is to take those contacts from a homeowner. And part of the reason that board members' emails must be made available to the owner is the legislature says, hi, you're a board member. Owners need an ability to contact you and talk to you about their concerns. So you have to have a way for owners to contact the manager and the board member. So when you start getting daily and sometimes hourly emails, it becomes very, very harassing, because obviously it impacts your ability to do your job. And so, how many does it take? How many emails does it take before it's going to be harassment? If you get an email every hour from a homeowner, I'm going to say that you got a pretty good case for harassment, unless it's a water situation and they're freaking out because the water's pouring in. Okay. Do they stop the minute we can get the water shut off? Yes. Okay, then there's not a case of harassment. But otherwise, if they're sending you an email every hour demanding something happen and it's not an emergency, you've probably got a good case of harassment. So what are your options? What do you do, right? I think that step one is you have to explain to the homeowner, I'm happy to help you, but burying me in emails is not going to help you, and it's not going to help me be efficient to get the job done. So you've got to put them on notice. If it continues after you've put them on notice, then what you have to do is shut them off, meaning block the email, tell them that you'll only accept any communication from them by snail mail, postal, U.S. Postal Office. You want to write me something? Write me a letter. I'm not taking your emails because you've abused that. You can't just absolutely cut them off. You've got to give them a way to talk to you. You've also got to create a way that they can still call in an emergency. There's got to be some ability for that somehow if you shut off their emails. Can they still call the emergency number? Can they still email an emergency contact information? If you've provided that, you can shut off their emails and say, I'm not going to take them. What if they continue to bury you or just find alternative ways? They use a different email address so that they keep circumventing the situation. You can tell them, look, you can send me all the emails you want. They're going to go into a separate folder with your name on it. And once a month, I'll open it up and I'll read them. And if they're legitimate requests, they'll be presented to the board. If they're not legitimate requests, they're going to be ignored. What if they ignore that too? At some point, you can go to the board and say, look, I need you to authorize involving the attorney. This is ridiculous. They're harassing us. They're wasting my time. I can't get to your, legitimate business work because I'm so busy dealing with these constant emails. And if the board then authorizes, have the lawyer send a letter. And that letter is going to be, dear homeowner, your manager is not there for your punching bag verbally or by email. And this is harassment. And it's not going to be tolerated and it's not going to be accepted. And what they're going to do is all future emails of yours are going to be directed to the attorney. And because it's misconduct on your part and abusive in the way you've done it, you're going to be responsible for the attorney's fees. Now, can we legitimately put the attorney's fees on their letter? And I'm going to come back to this slide, but I want to move forward and finish that sentence and that thought. As yes, those attorney's fees can go on their file in a couple of situations. If it's a post-Kiowa community, because under Kiowa, there's a section that any misconduct on the part of a homeowner, which causes an expense to the community, can be put back on their ledger. So if you've got a homeowner and they're in a post-Kiowa community and they're burying your board or they're burying your manager in emails to the point where you've turned it over to the lawyer and the lawyer says it's going to send a letter, that letter is going to tell that homeowner, hi, the board's not going to accept any more of your emails, neither is the manager. All of your emails are going to be automatically forwarded to me, the attorney, and all of the costs for me answering you is going to go on your ledger and you're going to be responsible to pay them. And here's the law that says I can do this. Now, if they're a pre-Kiowa community, that statute doesn't apply. And so then you've got to find authority in the covenants to put the attorney's fees on that person's ledger. And that's going to depend on a case-by-case basis whether or not we can put those attorney's fees on their ledger. But, one letter to a homeowner telling them you're going to start having attorney's fees, and generally the emails are going to slow down. Although, to be fair, I did have one gentleman who ended up with a bill of over $3,400. He was a post-Kiowa community and he ended up paying it. But again, it's one of those things of at what point can you get the attorney involved? Have you gotten to sufficient emails that it is harassment, and have they ignored it? One of the questions is, what about a 3 to 4 a day set of emails regarding topics totally unrelated to the property, more personal attacks and demands? Yeah, I think that definitely 3 or 4 a day are going to fall under harassment, especially if it's unrelated to the property. It's got nothing to do with the business you're in. That's clearly going to go back to this slide where you've got too many emails in a day, especially when it has nothing to do with it. Sometimes what you're going to see is, it's the same issue over and over and over, and the board's already voted on it, and the board's already said, we're done. This is not, we voted, we disagree with you, and we're not going to deal with this again. That can be harassment too, because it's not a legitimate issue. It's been voted on and it's been denied. The same with calls. Although calls, it's much easier. People get really tired of leaving voicemails, but again, they can fill your inbox so that nobody else can call. And that again is going to be something that you can talk about as harassment. We're done. Texts. As many of you know, David Furman gives out his cell phone number to everybody, and he had one homeowner who buried his email or his voicemail and his cell phone, and she buried him in texts. I don't necessarily recommend giving out your cell phone for just that reason, because they will bury your text. It just becomes impossible, the amount of text. One of the things that you can be aware of is if in fact you have that person who has just burying you in text messages. There's some programs, if you don't have them on your phone, they're not expensive. I don't know. I think you can get one for maybe $30 that will take all the text message and put them in a PDF so that you can save it to the file so you can show, if you have to, the harassment that's coming in. What about when it's happening at a board meeting? That's another one. That requires you getting your board to really help you work the problem, right? Sometimes you have to be very, very strict with your owners forum. And we'll talk about that in another slide. Question is, if the decks have been updated to meet Kiowa as of 2019, does that count as post-Kiowa? So the way Kiowa words it is, you can accept all of Kiowa's provisions when you amend your declaration. It's not just amending after Kiowa. You have to actually adopt the provisions of Kiowa to make you be a quote-unquote post-Kiowa community. So I'd have to look at the declaration and see if you accepted all of Kiowa to make you a post-Kiowa community. Again, get an attorney involved. That can help shut things down. Can you find them? That's going to depend on, what's going on and if you can find a covenant violation. Again, fines are only for covenant violations. They're not for harassment. I've had some circumstances where the manager had so many emails and they were they were personal. They had nothing to do with work. And they actually got the cops to go out and issue a harassment citation. Understand they had about an inch of paper, showing that they're going to take a lot before the cops are going to consider it criminal harassment. But when you get that many emails and you get that constant attacks, sometimes you can turn it over to the police. Can you ever file a lawsuit on it? That's going to depend. It really is. Harassment is one of those things that's very subjective. You have to think about it this way. Board members have been considered by the courts to be quasi-public figures. Because they're quasi-public figures, the court kind of looks at this as, hi, you're almost the same as a politician. You asked to be involved in this. You should expect to get all those emails. That's why, you asked for this position, you got voted into it, now you get the emails. As a manager, the court's going to look at you in the same way. Hi, you're getting paid to deal with these people. So you're going to have to show that the emails are completely out of control. They're completely nothing more than attacks. They've got nothing related to do with your job. If the emails are one after another telling you that you're doing the job wrong, the court might not consider that to be harassment. Hi, I am a homeowner in your community and I'm paying you to do your job and I don't think you're doing your job and I'm pointing out your failures. The court may not consider that to be harassment. Question about what if a homeowner is continuously complaining about a dog walking around above them and they think it's excessive noise? Well, unfortunately, that is your job, right? If it's not a barking dog that you could tell them, call Humane Society, it's just a dog that is walking above them, you can tell them, you'll look into it. It's going to depend on whether or not anybody else, noise complaints are always really difficult because they're very subjective. And if you have your units where one's above another, you may only have one person complaining. And if nobody else ever complains, you may have to say to them, look, I don't have any grounds just because the dog's walking around above you that I can issue a fine for a noise complaint. I have a HOA where the board president harasses the other board members and the homeowners are all too scared she'll retaliate. Let me come back to that one because we're going to talk about board members in a moment. How should we deal with a partially burned violation letter placed beneath a rock? Sorry, I'm trying to read the whole thing. Beneath a rock on a board member. If you take it to be a threat, which is what I'm gathering, I would call the police. Again, you're not there to do anything where there's a threat involved. What if a homeowner constantly complains? Oh, same question in a different place. Sorry. Okay, so let's go on. I'll come back to the one on the board member harassment. One of the things we often have as the means of harassment, as I said already, was that homeowner who brings up the same thing over and over and over again. This is where you really want to look at your policies, be aware of your conduct of meetings policy, and really tell them, look, this is not a new issue. We're not going to deal with it as a new issue. It's already been decided, and move on your agenda. When you're talking at the board meeting, I said you have to use your board. That means your board and you have to be in agreement in advance, right? You have to have the discussion with your board member and say, look, we know Sally's going to show up and we know she's going to have a fit about the same thing she's had a fit at every meeting, right? So how are we going to handle it? We're going to stop her and say, we're not going through that again. We've already discussed it. It's not a new discussion. If she continues, right, she tries to yell or scream, you have to be willing to basically call her out as violating the code of conduct and adjourn the meeting if she won't stop. Okay. Now, right now, we're all kind of in this great place where we've got Zoom. And what do we do with Zoom? We simply hit that mute button and cut them off, right? It's great. It's helpful because we're dealing with things where we have the ability to shut them off. But sooner or later, we're going to be back having meetings in person, and we're going to have that homeowner who refuses to shut up, refuses to stop yelling, refuses to stop screaming, whatever the case may be. The only way you really shut that person down is walk out. And I know that's hard for you guys because you want to get your job done. You want to finish the board meeting. You've got work that has to be completed, but it's the only way to control that person. Okay, you can't out scream them. They're not going to listen. And so you've got to call them out, tell them you're acting unprofessionally. It's not acceptable. It's a violation of the code of conduct. And if they will not shut up, you've got to just walk. It's the only way to control them. At the next board meeting that you're going to have, then hire an off-duty police officer or hold the meeting at the police department. And when they start yelling and screaming, demand they leave. And if they won't, walk in and ask one of the officers to remove the person. It's your meeting. If you don't want them there and you have the right to remove them if they're violating the code of conduct, have the cop come and remove them. Okay? It's the only way that you can actually take advantage of that. Sorry, when I click on my chat, it removes my PowerPoint. So let me take a look at this and I'll come back to it. Is it harassment when a board member continually reports violations for one homeowner but not the entire community? No, it might be selective enforcement. So one of the things that you want to do when you're looking at a complaint, if a homeowner, think about it. Most homeowners only report their neighbor. So you're generally only having complaints from one person anyway. So you want to go verify if the complaint really exists. And if you can verify the complaint is a valid complaint, then you want to go ahead and issue the violation notice. Homeowner says he has become president because board has been dismissed over and over. Lisa, I don't understand your question. Board has been dismissed over and over. Should we be able to get a restraining order? I don't understand the facts that you're trying to provide to me. So type more. Let me see. Give me more information. Let me see if I can clean it up. Let's talk about homeowners and they're harassing other homeowners, right? You've got lots of times where homeowners are trying to use the board, right, to go after another neighbor, right? Whether it's parking, whether it's dog poop, barking, not on a leash, whatever the case. You know, the first thing that you need to do as a manager is evaluate if there's a covenant violation. If you get one owner who hates another owner, like the board member who obviously hates another owner, step one, verify the violation really exists. Is it something you can tell? Is it something you can show? If in fact you can verify the violation, issue the violation notice. One of the things I know you guys frequently get pulled into is one owner who is complaining about another owner and they're using the board to get after each other, right? Constantly submitting violations, constantly demanding fines, etc. If in fact there's a violation, you've got to issue the violation. The fact that you know that your neighbors hate one another is unfortunate, but if there's a violation, you're going to have to issue the violation. Obviously, if there is no violation, you get to say, I'm sorry, there's no covenant violation here, and my abilities are restricted by the covenant. So I don't see a parking violation, so I'm not going to issue the notice. You haven't proved to me it is your neighbor's dog who's pooping in your yard. Get me a photo. If you can't prove it, I can't take action on it. Obviously, on the dog poop, the dog barking, or the not on the leash, you can always direct the homeowner to call the police, animal control, whichever is the case, depending on where the community is located. Sometimes it's code enforcement, sometimes it's animal control, but you can always direct them there. If you don't have it in your covenant enforcement policy, I highly recommend changing your covenant enforcement policy, but your policy should state that there has to be sufficient proof for the manager to move forward on the whatever the violation is, or it's the manager and the board's discretion to not move forward because there's not proof. So that you can tell that homeowner, look, I have to be able to prove this. If I can't prove it, I can't move forward, and I don't have enough here to move forward, so I'm not going to. But that, again, sometimes you need to amend your covenant enforcement policy to really very clearly state that you're not moving forward unless there's proof. The noise, the smells, the smokes, where one homeowner's trying to use you to basically harass their neighbor, again, that has to do with whether or not you feel comfortable that you've got proof. If you don't have proof or you don't have a covenant, you've got to tell them, I can't do it. One of the things that becomes difficult, and I've already seen a couple of emails here, is when the board member's the one who's either being complained against or is doing the complaining, because that becomes a conflict for you. You're hired by that board, and I know you don't want to have to put yourself in the position where you've got to issue the violation letter to a board member. One, you have to remember you work not for the board, you work for the association. Your contract is with the association. So if you get a complaint and it's valid, you shouldn't care that you're going to send a violation letter to the board member. I know it's going to suck, and maybe you want to make a phone call first to try to politically say, hi, I'm sorry, but I got this and I have to send the notice. But you really need to. And when you do send those, it actually makes you and the HOA that much more solid in court on every other member who gets one of these. Because then when you take this in, I can say, hi, what happens if you get a complaint against a board member? And you can say, I send him a violation notice just like anybody else. So it strengthens your testimony. It strengthens the fact that there's no selective enforcement. It's just really hard personally, because obviously that's really frustrating. I have a bunch of questions. So let me look at a bunch of the questions. Sorry. What if you have a tenant harassing a homeowner over dog poop and the tenant has installed a camera that looks out to the parking common area? It really doesn't matter if it's a tenant or an owner. If that person has a camera video and they can prove whose dog is not being picked up after and they give you the video, they've proven to you the violation exists, you send out the violation notice. It really shouldn't be, it's not harassment if it really is a violation. Can taking a photo be dangerous? I have been yelled at when attempting to take a photo of a parking violation. Yeah, a lot of people get yelled at when they take pictures of parking violations. I don't recommend you do anything that's going to put your life in harm's way, but getting yelled at isn't the same as being in harm's way. That's just getting yelled at. So there's no violation of law. A lot of people will yell and scream, you have no right to take pictures, and they're lying. They're full of it. The law is pretty clear that you can take a picture. If I'm standing where I'm legally entitled to stand, I can take a picture of anything I can see. Okay, there's no violation of law. Doesn't mean it's not going to make people mad. And I've had people get really mad. I walked through a community before, prior to a trial, and I took pictures, and I had all kinds of people screaming at me. And I said, yeah, I'm on a public path, and I have every right to be here, and I'm going to take pictures of whatever I want to take pictures of. You got to have thick skin to be a manager. I'm sorry, that's hard, but that's pretty much how it works. What if our covenants say something like no illegal activity and we have someone suspected of selling drugs and stealing cars? Okay, that's where you call the police. Do not get yourself involved with that ever. Run away and say, hi, if you want people to be taking, issues to the police, let them take it to the police. So like if you have Mrs. Cratchit, and that's going to date myself because it's from Bewitched. But if you have a Mrs. Cratchit in the community who complains about everybody and tells you that she's certain that her neighbor is selling drugs, explain to her she needs to call the police on that because that's not your job. And that if the police issue arrest paperwork, get a copy and you'll be happy to follow up in addition, but you're not going to be, you're not the person to call if they suspect there's illegal activity. And you can explain to her that you can't call the cops for her because the cops don't want any hearsay information. They're going to need to know from the person who actually saw it. So if you have somebody telling you they saw a crime, you tell them, call the police. So you don't feel like owners installing cameras that record other owners' doors as well as their own is a violation of privacy? No, it is not. Like I said, if you're standing on your front porch and you can see across the street into your neighbor's front porch, anything they do on their front porch, they should know that you can see it. And if they want to go out on their front porch and do whatever, hi, that's their choice. I don't have to hide or close my eyes. I have a right to look out. And anything I could see, I can put a camera up to record. Now, the one weird part of this, and I haven't seen it addressed in the courts yet, is that the Ring cameras also do video and voice, right? They record what they hear. And I have not heard any courts say if that's wiretapping or violates the eavesdropping laws in the state of Colorado. Because in Colorado, if I'm part of a conversation, I can record it legally, well, except for attorneys. Take attorneys out of the mix. But generally, if you're a person and you're part of a conversation, you have a right to record it if you're part of the conversation. But if you leave, you can't leave a recording going. That's considered eavesdropping and it's illegal. Well, a Ring camera will record not only video, but sound. I have not seen the courts deal with the issue that might be eavesdropping. So I don't know what the courts are going to do with that in Colorado. Obviously, we see all kinds of issues that are a nuisance that come up and, try and become an issue of whether it's harassment, right? Because again, it's what's an annoyance? And people start trying to make you deal with covenant situations, and then others call it harassment, right? And we've already seen that in the questions. What about when people are saying it's, noise, it smells, it's, what's going on? And you as a board member have to, again, walk that fine line of what to do versus can you even do it? One of the things that I always want to caution people on is anytime you're questioning whether or not it happened, the court is going to question it even more. So if you aren't comfortable, you're not certain, you don't think it happened, go back to whoever's complaining and go, I need more proof. I need to make sure that I'm not making the HOA be liable for accusing somebody of something, and I can't prove it happened. Okay? You need to look at some of these situations. Sometimes it's going to be a nuisance that you're going to try and squeeze something in on, like the woman who's complaining about the dog upstairs that's so loud and it's jumping around and it's exceptionally loud. I mean, with all of us being, stay at home, we're seeing lots and lots of situations that are being brought to our desk and our door as managers and HOA people. Fix this. I can't work in these conditions. This is a harassment to have to listen to this noise all day. It's horrible. And sometimes you're going to have to say to that homeowner, look, I've got to say, no, I can't prove this. What you've given me is not enough to prove it. And if I can't prove it, I can't move forward on it. And hopefully you can look to your covenant enforcement policy to help you say no. I've got questions at another spot. Hold on. Okay, hold on. Is it? Okay, so Lisa asked questions says he keeps saying the board members are dismissed. I tell him I don't know what he's talking about legally, so just because some homeowner says they're dismissed, that makes no sense. It doesn't make sense to me. Sounds like the homeowner calls vendors. So if the homeowner's calling vendors, you can send him a demand letter and tell him to stop. He has no legal authority. It's tortious interference with your contract. Can you go to court and get a protective order for the HOA? No. So protective orders are issued when, and I'm going to come back to that, or protective orders are what used to be called a restraining order, and you can only get it for threat of harm. So if you got a homeowner saying, hey, I'm going to shoot the snow plows the next time they drive by, you, the manager, cannot get a restraining order for the snow plows. You can call the cops and tell the cops that this guy's threatened to shoot your snowplow driver, and let the cops deal with it. The snowplow driver, if you tell him, could go get a restraining order because he's the one being threatened. You can't get a restraining order against him threatening someone else. But you could definitely call the cops if he's, threatening, but it has to be a threat. You can't get a protective order for harassment. Can you ask someone to not audio record a board meeting or we will adjourn? That depends on whether or not your documents, your conduct of meetings policy says no recordings. If your conduct of meetings policy says no recordings and someone starts recording, yes, you can adjourn. But don't threaten to adjourn unless you're actually going to get up and walk out the door. HOA quiet policy says 8 p.m. to 8 a.m. A kid is riding his motorcycle for hours in the parking lot driving a loud remote control car for hours on end. Both cause the dogs in the condos to go crazy. What kind of rule could prevent those nuisance type activities? Well, I mean, it sounds like you already have the rule. If you have a rule that says it's quiet time and it's a very loud motorcycle or it's a very loud remote control car, then it's a violation of the quiet time, and send him a violation. And then every time he does it, make sure that you're fining him as much as possible. You wouldn't need a further rule to do so. You just want to make sure you enforce the rule you've already got. And then again, you also want to make sure that you're giving his opportunity for a fine hearing and then fining him as much as possible. Again, it's probably going to fall under your nuisance provision. But one of the things about most harassments, often, neighbor to neighbor, are going to fall under the nuisance provision in some respects, because it's going to be an unreasonable annoyance or embarrassment to a neighbor, right? Most of the time, your nuisance provisions are going to cover what, owner to owner kind of harassment is going to happen. So you want to make sure that you just, again, document. One of the things is, if it's noise, try to get another neighbor who can hear it, so you get 2 complaints. You don't want to have just one person. Because if you've got to go to court on it and you only have one person, you're going to have a very hard case to make. Remember, you're not the covenant enforcement police. You're just covenant enforcement. All right. You're only enforcing what's in the declaration. If it's Kiowa, remember, if you're a Kiowa community, you can escalate it to the attorney, and you can make a big kind of imprint on the homeowner by forcing it and getting attorney's fees. If there's any kind of safety issue, you want to make that a police issue, okay? You do not want to have this situation where you're trying to have police, and this is what really gets confusing to homeowners, right? Do they call the police? Do they call you? If you have a homeowner who is harassing their neighbor, oftentimes your letters are going to fall on deaf ears. They're not going to listen to you. So if you can get the police to help you, even if the police don't charge, they go knock on the door and go knock it off. That's often enough to get the homeowner to back off, right? So do consider bringing the police in if you can. But remember, anytime you bring the police in, what you're trying to get the police to do is not enforce your covenants. Don't tell them you need their help to enforce your covenants, because they're going to walk away. They're not going to help you. What you want to emphasize to the police is, you got one neighbor harassing another neighbor, and can you get them to help you? And then sometimes they will. Not always, but sometimes. And again, it's obviously going to depend. Is it Friday night and they've got other things going on or not? But police are a good option. What about other options? It depends on what the covenant violation is, right? Can you use any of these other external resources to help you with it? Sometimes you can. Sometimes, obviously police department are going to be great for any violent behaviors, any threats, and harassment is a criminal violation. I mean, I threw that slide up there first for a reason. And sometimes the harassment and the constant complaints, one neighbor against another, they're going to rise to that level of harassment, and you can get the police to step in and help you. What about any of these other guys? Well, I mean, code enforcement is going to help you if it's an issue of, are they building it too close to somebody so that the neighbors feel like that's harassment? Animal control for the dog complaints. Use the other departments as much as you can to help you deal with some of the issues you can deal with. Obviously, if you got hoarding issues, that you're going to use the fire department if possible, sometimes the health department, because that's an issue that becomes, it's harassment because you got one neighbor yelling at another neighbor about where they're putting things. Sorry, guys, I got to click over here to see a question. Can you utilize mediation? Absolutely. You got two neighbors going at it, mediation is perfect. One of the things you may want to be aware of is you may not be able to get just the two neighbors into mediation. I've had my board members agree just to get out of the middle, right? Let's all three go to mediation, the board and the two neighbors, right? The minute you get into mediation, the mediator is going to understand the HOA has nothing to do with this situation, nothing at all, and we're just dragging everybody in. And then the mediator will deal with the two neighbors. And for the most part, I've had the mediator actually tell me and the board member we could leave. And we did. And we just let the two neighbors actually debate all the issues that they had because HOA really wasn't involved. So if you can get a mediation, that's great. We have one situation where a homeowner has lost tenants in their property because their neighbor causes problems. And they have gone round and round, started a petition to get as many letters as they can against the neighboring tenants. The intent is to get the tenants evicted. It's our understanding the HOA can do nothing to get a tenant evicted. Correct. It depends. Sorry. I know you guys hate that answer, but it depends on what your documents say. So if your documents have things that say owners may lease, but owners must make their tenants comply with the covenants, then you can send a violation letter to the owners for the tenants not complying. And you just keep sending, fine letters and threats to the owners for the tenants not complying. And eventually the landlord will make the tenant move because it's costing so many fines. Some covenants are a lot more inclusive and actually give the HOA the ability to evict the tenant, but it depends on the covenants entirely. Every covenants are different. You got to look to what your covenants will let you do. So yeah, if there's no covenant violation and it's just neighbor to neighbor dispute, a petition isn't going to help. I mean, if you get the petition sent to you, the HOA, I would recommend you, the HOA, send it to the owner of the unit where the tenants are, so that the owner knows that his tenants are making all the other neighbors mad, right? I got a question over here. Hold on. Whoop, went the wrong way. The harassing board president. When your board president is the person who's harassing it, you need to remember that go back to where we started. Is it really a covenant violation, right? If it's really a covenant violation, it's not harassment. What it is he's a bully. When he's bullying his other board members, they're going to have to stand up for themselves. You can't stand up for them. You can try and utilize Robert's Rules of Order so that when the board president says, I want to make a motion, we vote on X, somebody else has to second it. So that, again, you're utilizing rules to try and control what he's doing to the other board members. But if the other board members won't stand up for themselves, there's nothing you can do about it as manager. Those other board members are going to have to try and get other homeowners to join the board, or they're going to have to get other homeowners to vote in a new person. If he's really, really bad, maybe the other board members want to work with the other homeowners to recall him. But again, that's you, the manager, can't do anything to stop that unless your other board members are willing to do something, right? Compliance with the law, we kind of already talked about that because there was a question that came up. But again, always, when you get those questions of you think one owner is harassing another owner and it's illegal, right? Call the police. Tell them to call the police. That's not your job. Remember, your job is only to govern the property, not the people. Again, it becomes a real push because it makes it really hard to live next door to someone who's constantly noisy and constantly loud. And sometimes you become the person who has to almost be the parent between two warring children. But you're not, okay? Your job is about the property, and you have to relate things back to the property. And when things are going off track and things are being trying to pull you in to deal with stuff that's not your job, take a step back, pull out the covenants and go, tell me where it's in the covenants that any of this is at issue. And if it's not, push it back. It's not yours. I can only work on the covenants. Don't take on a security role. Okay. If you take on a security role and you miss something, you now may have made the HOA liable. If you start creating a situation where you are trying to take on the safety, people are going to expect you to continue that. And then if you miss something, they're going to yell, I relied on you and you didn't do your job because you were acting as security and I expected you to make sure that I wouldn't get mugged, and I got mugged, so now I'm going to sue you. Don't take on a job that's not yours. It's not yours to stop people from harassing one another if it starts getting to the point where it has nothing to do with the covenants. We talked about this already. The harassment of vendors. Again, owners have no right to direct vendors. Only the HOA has a right, and your right. And you can, you want to start with the fact that it's your contract. It's your contract with the snow removal. It's your contract with the lawn maintenance group. Owners have no right to talk to your vendors. If they do, it's tortious interference with contract. Tell them to stop it. If not, escalate it to the attorney. If you are post-Kiowa and you escalate it to the attorney, you're going to put attorney's fees on their ledger because they're interfering with your vendors. Okay. One type of harassment that has nothing to do with your covenants, but has been dumped on your plate. Thank you, HUD. In October of 2016, Department of Housing and Urban Development adopted a rule that said, if one homeowner is harassing another homeowner based upon race, color, religion, national origin, sex, familial status, or disability, that the HOA has to use whatever ability it has to stop it. Now, they have not spelled out what ability they think we have as an HOA to stop this conduct. But you as managers need to know that if you have one neighbor calling another neighbor names based upon their race, you need to step in and do something. My recommendation is, because obviously there's nothing about race in your covenants. Your letter to the neighbor calling names is, dear neighbor, that's unacceptable. It's not going to be tolerated. Stop it immediately. You send a second letter to the owner that's being called names and go, I'm horribly sorry you're being called names. I really have no authority to do anything under the covenants. My job is only to enforce the covenants. I can't find anything in the covenants where this fits, but I sent him a letter telling him it's totally unacceptable. However, if this continues, you should definitely contact the police, and maybe it will fall under a hate crime or something. There's very little you can do, but you need to take some step, just even if it's that one bluff letter, so that you can't have HUD come after you and say you could have sent a letter at a minimum, right? You're kind of in between a rock and a hard place here, because again, it's not really anything that is in your covenants to deal with this situation. But if you do nothing, you're definitely going to get hit and slapped by the HOA. So you want to make sure that if you get anything like this, if any of those neighbor situations turn on the race or color or religion or anything of that, send letters to both sides, but do something. Don't do nothing and say that's a neighbor to neighbor issue. Don't do that. That will get you in trouble with HUD. And that's it, unless I have any other questions. And I think I had a question here that I did not answer because I wasn't certain. So Kevin asked a question. If the complaint is a violation of criminal law, do you have to wait until it's proven that they violated the law before you can take action? No, you do not. So because you're sending a letter to them saying, because you're under a civil standard, which is preponderance, not criminal. So if you sent a letter saying, we believe you violated this law and we know that the police cited you, that would be sufficient to meet your civil obligations and your proof under the civil arena, because we only have to prove 51% that they committed the crime. It's not beyond a reasonable doubt. So you don't have to wait till they enter a plea or they are convicted. You could go ahead and send a violation for that if in fact the police pick them up or you have somebody willing to come testify against that. Okay. And I think that's all my questions, and I'm out of time. So thanks, everybody. Have a great day. And Sean in my office will get you your CMCA credits. Take care.